My name's Mark Hefner. Again, thank you guys for being here. I'm the landowner advisor, considered the landowner advisor for Braun and Gresham and Plateau Land and Wildlife Management. I'll be moderating, helping Margaret navigate through the slides and communicate with you guys. Owning rural land in Texas can be a bit complex and can come with some issues, and it can be very broad. My role as a landowner advisor is to understand your issues, listen to those goals, perhaps advise you on the best route to resolve that, or even connect you with an expert that can help. Braun and Gresham is a law firm that represents rural landowners and the very unique issues they can face. Not many people have their experience. So one of the things is rural real estate transactions, others are eminent domain cases, even conservation strategies for legacy land. So again, a very unique situation they position themselves in. Our sister company, Plateau Land and Wildlife, assists landowners with wildlife management and ag filings, and also has a team of expert biologists that can advise landowners on how to better manage your land. So again, great assets there. Today, I'd like to introduce Margaret Menicucci. She is an attorney and counselor and will be giving the presentation. Margaret and I have been working together for years, helping landowners with a variety of needs. And also, as a personal note, Margaret created my family's estate plan. So that gives me a lot of comfort. And again, Margaret's wonderful to work with. We're going to be using an interactive approach today. Since we have a relatively small group, we're going to allow you to ask questions real time. You will have to unmute yourself. So navigate around on your screen and you'll see something looks like a microphone with a line through it. Unmute yourself if you wish to talk. You don't have to, just so you know. If you're not comfortable with asking questions in front of the group, or you have something confidential, please don't share that if it's confidential. You're going to have our contact information at the end of the presentation. You can reach out directly to Margaret and or I. You can also choose to use the chat or Q&A section. Avalon's going to jump in here in a minute and give us a little more details on that. Either way, whatever you feel comfortable doing, please don't hesitate to reach out. We're here to help you. So lastly, we're going to be recording the webinar today. This is going to serve a great purpose for a lot of people, potentially you if you want to go back and review it, but also you can share this with others. We're happy to answer your questions offline. If you don't feel comfortable with the fact that we're going to be recording it, again, don't hesitate to reach out to us in a different format. So Avalon, can you jump back in there and give them a little more details on how to work the system?
Certainly. So if you're trying to just type in your question using the Q&A box, you should simply be able to scroll over your Zoom screen and see a toolbar that either pops up at the top or the bottom of that screen. And on that toolbar, you should see an option for Q&A. If you click that, you can type in your questions directly. And if you want to just speak your question out loud, feel free to hop in. Anytime that you do have a question, on that same toolbar, you'll see an option to mute and unmute yourself. Like Mark said, it looks like a little microphone. So you can just click that and then hop right in and ask your question.
Fantastic. Thank you. So without further ado, you guys have listened to me jabber enough. I'm going to introduce the star of the show, Margaret Menicucci.
Hi. Well, welcome and thank you for spending your noon hour on a Tuesday with me. We're going to talk about putting together your estate plan and what is really from my perspective, I want you to be thinking about and that I think is important. And as Mark indicated, we're here to help principally owners of rural land. And I think that our experience in planning with rural land, how do we handle that asset in the estate plan, is unique. And hopefully you can gain some more understanding of that today and have some questions answered. I am going to open up for questions as we go. So I think that helps the conversation. So don't hesitate if you need me to clarify something or if something comes into your head and you want your question answered. Avalon is helping me with the presentation, so she's going to advance the slides for us. Thank you so much. When you're starting to look at your estate plan, a lot of people think, oh, it's just a will or it's just a trust. And I want to open your mind and look at it as a broad way of how you're managing assets during your life and when you pass. And so some things we want you to consider is, how do we protect those assets and you and your family against financial exploitation? How do you plan for long-term ownership of rural land? If leaving a legacy is important, how do you do that for family or for your community? What do we know about managing future changes in the law? And we know it happens. And so what are some ideas there? And then finally, and this happens to a lot of people, is how do we make sure it's a fully implemented estate plan? So some people get part of the way and they don't get finished. They might do some documents, but don't coordinate them with other assets. And so we want to remind you that there's kind of a good to-do list that you want to make sure you get through so that you've got a comprehensive estate plan. Okay, next slide. Evelyn, thanks. You know, what is estate planning? Like I said, it's more than just a will. And estate planning allows you to protect your property. It allows you to provide for yourselves and your loved ones without giving up control of your affairs. It allows you to plan for the possibility of your own disability. So it's not just a death, it's also if you're suffering incapacity. It allows you to give what you want to the persons you want, the way you want them to receive it. Sometimes we want to protect those assets a little bit, and when you want them to receive it. And then we also want to be saving every tax dollar, professional fee, and court costs that are legally possible. And on that last one, you know, taxes come to mind a lot, but also when we're estate planning with our clients, we want to be using tools in a way that minimize the frequency or the possibility that they will get into an extended legal dispute, because that is something that erodes estates very seriously. Okay, first consideration. Here we go. How do we, and that was a summary of my 5 considerations, so you're going to hear them again. How do we protect against financial exploitation? So there's a couple of options, and one of the things that's always an option is you do nothing. You don't have a plan. And so if you were to become mentally incapacitated, meaning you don't have the ability to understand what you own and control your own affairs. So this could come from a head injury, or it could come from dementia, or like a brain tumor. I mean, these are sad things we have to think about. But if you become incapacitated and you haven't really planned who takes over for you, then the people around you have to go to court and initiate a guardianship. And there's a guardianship of the person and the guardianship of your assets. So the guardian of the person makes medical decisions for you, and the guardian of the estate handles financial items. And just as I indicated on item 5, that's costly. And because you're incapacitated, you don't have any say in that. So it could easily be that someone steps in and convinces the court that they should be your guardian. It's really not the person, you know, maybe the relative that you would have selected. So instead, we want to do something. And what you can do right now is you can execute powers of attorney, a financial power of attorney and a medical power of attorney. And in those powers of attorney, you designate the agents that you want to take control of your assets or your health care if you're incapacitated. And these documents can be set up so that they don't kick in unless you are determined to be incapacitated. So you're not giving up any control, but you're planning for a future event in which that could occur. Another option some people use is a revocable trust. And I'm not going to spend a lot of time on that. It's a little bit more of a complex document, but what we do with a revocable trust is set up a trust for your assets during your life. We title those assets in the trust. So the trust kind of manages those assets now. You're the trustee. But if you ever become incapacitated, you've designated in that trust a successor trustee. So it's similar to the agent under your financial power of attorney. If you did a revocable trust, you'd still want to do your powers of attorney because there's some activities in your life, some things like IRAs that we really don't want in the revocable trust that we're going to want to designate an agent to have control for those. So those all work together. And this advanced declaration of guardianship is a very simple document that says, look, court, if you're ever looking at this document, because there's a guardianship proceeding going on involving me and my assets, these are the people I want to be my guardian. So that closes that issue of what if someone you don't want to be is appointed your guardian or seeks to be appointed your guardian. You're trying to declare to the court, you're trying to inform the court of the future, that these are the people that you trust. Next slide.
Hey, Margaret,
Oh, yeah.
we got one question, and you may get to this. It may be, again, depending on in your presentation. The question is, do you recommend separating the mineral estate from the surface if both are owned by the same parties, i.e. two LLCs?
Avalon, quick, go to the next slide, because that's a great question right now. Thank you so much. I don't usually recommend separating the estates. So I can just start with a quick and dirty answer.
Sure.
To the extent we can keep the mineral and the surface together, I think that's simpler and it's better for most folks. But you raise in the question the potential of putting some assets in a business entity like an LLC. And what that does, this is still protecting your assets during your life. Is what it does is it can protect, it has the potential to protect those assets from a possible personal bankruptcy or a judgment creditor, that kind of horrific situation where you had a terrible accident, there's a judgment against you that exceeds your insurance, and they're trying to find assets and attach assets to collect that judgment. And so if you have a non-homestead property in an LLC, it's going to be much harder for that creditor to reach it. It will be almost impossible. So that, I hope, might have been kind of what you were thinking in the question. I don't know for sure, but like, some assets are super valuable. Families care a whole lot about their minerals, and in some parts of the state, the minerals are generating a lot of income. Would I want to separate that out? I'm less inclined to do so, especially if it's homestead property. And then I think that you would want to evaluate all the facts to consider whether a severed entity or just the whole property goes into an LLC for protection.
Okay, that's great. To the attendee, if you don't feel like we answered that, please let us know and send us a clarifying question if we didn't. Thanks, Margaret.
Yeah, and I'm touching on a lot of topics that probably could benefit from like a half-hour webinar just in and of themselves. So I'm not going to be surprised if something's not clear, and that's why I encourage you to ask questions. Or if what I really hope is that something kind of teases your brain and thinks, oh, I want to learn more about family limited partnerships. And then I encourage you to contact me afterward and we can have a conversation about that. But you'll see in Texas a whole lot that we use business entities like a family limited partnership or a limited liability company, that's an LLC, to hold non-homestead property. So your homestead might be in town, but you might have some rural land out further out in the county, and that second property doesn't qualify for homestead protection. And so we for asset protection purposes may want to put it in a limited partnership. And the benefit of it, there's an additional benefit, is that it's easier to transfer that to the next generation when it's in a business entity. And I'm carving out homestead because in Texas, the homestead protection is tremendous, and it provides a lot of help in terms of protection against bankruptcy and judgment creditors. So we don't want to put homestead property in a limited liability company most of the time. Okay, next slide. Considerations 2 and 3, I mentioned them, they really go together. And one is planning for long-term ownership of the land and leaving a legacy for your family or your community. So how you plan around that really depends on your goals, and so I have clients who have either inherited or acquired the rural land, and it's important to them and they love living out there, but they acknowledge that their kids are not connected to it. And so it could be that the goal for that client is on their death and their spouse's death, if there is a spouse, is that it's sold and that the value of that land is what goes to the kids. Or you have families where there are next generation that is connected to the land. It's either been in the family a long time, or it's just everyone's excited about the new acquisition to the family. And you do want to see if it can pass to children and grandchildren, so that they have a kind of a sanctuary, a place to go as we rapidly urbanize around the country. They have this quiet and beautiful place that they can call their own. So that's why goals really drive our planning. And your goals are always valid, and they're your goals. I don't want you to feel like you come in to talk with a lawyer and they're my goals that we're trying to achieve. They're your goals. And I want to listen to you, and I want to help you flesh out those goals first. And then we figure out what are the tools we use to really achieve those goals. So next slide, have one. Okay, so planning for long-term ownership. So that's the second category. It's like client comes into me and says, my family loves this land. It's been wonderful for all of us. It's great for the little kids to run around in. I want my family to continue to be able to own this. So then we have to think about, is there a structure that's going to help us pass it on? Is that structure going to be a trust? Is it going to be a limited partnership? Are we going to write that into the will, or are we going to create it during your life? And the bullet above that, balancing gifts among family members, acknowledges that sometimes one or two of the family members really do want to enjoy the land, and one really has moved away, and they have a different life in a different part of the country, and it's not going to happen. They're not going to come back and use this land. And so if you give high value land to the other two kids, what are we doing for this kid that we want to treat with some equality and equity? It may not be one-to-one, but how do we balance our gifts out so that there's goodwill, and that, again, your goals are met? So those are the kinds of questions we ask. And I feel like these are very unique questions for owners of rural land. And then the second piece is, it is great to pass on rural land. As most of you know, it can be income producing. It often is not income producing. And so we have to think about what is going to help our descendants continue to maintain the land financially. Are we going to need to leave them some kind of endowment? Are we going to put it on their responsibility that they take care of it and they steward it and create their own funds? So that's just part of the planning. Next slide, thanks. Then this is more about leaving a legacy. So I think sometimes it is a legacy just to leave the land for your children. Sometimes it's been a great investment and the land gets sold, and what you've provided to your, and I say children, but not everyone has children to pass on to. Sometimes it's relatives, sometimes it's dear friends. And so please kind of hear that when I say it. It's really the beneficiaries that you care about. Sometimes we sell the land to give them a very nice gift. Some of our clients come in and say, I love this agricultural character of the land. I love the wildlife character of the land. I am in a county where a city is rapidly encroaching. How do I leave a legacy that is more of a natural legacy, or a legacy that reflects Texas's rich agricultural heritage? And so we might be able to do that through conservation strategies, like through deed restrictions, through conservation easements, through kind of limiting subdivision. You can still have a subdivided property that brings revenue to the family, but it's not subdivided down to tiny little parcels. It might be subdivided into ranches or ranchettes that maintain that agricultural feel. And then the last thing we always talk about, if it's within the client's goals, are philanthropic gifts. Sometimes we look at the community that we've lived in, that we've contributed to, that has helped take care of us, and we want to do some giving back. And sometimes we want to balance that with, I want to make sure my family's taken care of. But once I know they're taken care of, I want to ensure that my community gets something from me as well. And that is always on an individual basis. And really, I want to help you think through that if that's one of your goals.
Great. Hey, Margaret, we just got another question come through, and I think it may have correlated with that last slide. I think is a transfer on death deed recommended instead of maybe a trust or will?
So I'm going to give you the best attorney answer that you hear all the time, and that is, it depends. So it depends. And I will say there are some transfer on death deeds are relatively new. They were authorized in Texas, I think, in 2015. And they're also called beneficiary deeds around the country. And I think a majority of states have them, but not every state. And it's like putting a beneficiary designation on your property. And sometimes it's really helpful and really efficient. The challenges with transfer on death deeds are that they're relatively new, that the creditors can pursue that asset for a period of 2 years. So it's not going to provide any creditor protection. Not that it's expected to, but know that that asset could be taken away from your beneficiary if there are debt issues. And the title companies are still a little nervous about them. I think they're getting better at it, but they're nervous about them in particular for that creditor issue, because how are they going to ensure title if they're not 100% sure that the debts have all been paid if a creditor has 2 years to go back after it? So that's the issue. I'll tell you when I use them. Sometimes I use them to transfer title between spouses. So when the first spouse dies, we still have a will or a trust, but we put a transfer on death deed on the house, giving the house to the second spouse, and it makes our probate a little more efficient. That's mostly when I use them. Or, I do think they can be used when there are no other assets in the state and there's just a property. And again, you've got a client who keeps up with their bills. If it's a situation where debt might be a problem, then probate is a better place to be, in my opinion.
Okay, fantastic. Thank you, Margaret.
Yeah. Okay. What's our next one? Managing future changes in the law. So this is kind of a different direction, but I find when I talk with clients, when I first meet with them, sometimes they come in and they're really worried about, how do I pass my estate on without paying any estate taxes? And it's because for years and years and years, we had an estate tax exemption that was pretty low, and it was very difficult for owners of rural land because you might have a lot of land value, but not a lot of liquidity. Back in 2012, our estate tax exemption jumped up to 5 million scaled for inflation. And that helped a ton of people. That meant that you had to pass 5 million in assets to your kids or your friends, other beneficiaries, before you got taxed with an estate tax. In 2017, that was doubled. The exemption was doubled, and it's scaled to inflation. So it changes every year. And so right now in 2021, it's 11.8 million per person. And that means spouses can have, almost $23 million in state tax exemption. So I always tell my clients, if you're worried about having a taxable estate, then we're all really excited because you have a 12 or a $23 million estate. This tax exemption expires under its own terms in 2025, and it'll go back down to that 5 million scaled to inflation. Congress could change that anytime between now and 2025. They'd have to go through their whole legislative process. The president would have to sign it. So it's not a sudden change, but there is some uncertainty that I can't promise you that it's always going to be there. So we want to kind of always keep our eye on that. Because there's no estate tax, there's no or that the estate tax is imposed on very high value estates, we start focusing on the capital gains tax when we're planning and thinking about how do we minimize capital gains tax if we pass the property to our children or other beneficiaries and they want to sell it. So we do some planning around that. The next thing I want to point out is changes in the law. Is there have been changes in the rules related to passing on IRAs and 401ks. This happened in 2019. When we pass them to children or other adults who are more than 10 years younger than the person who created the IRA and the 401k. And so I just list these as an example of not that I want you to, we're always kind of trying to keep track of changes in the law. And so for you, people ask me, when do I update my estate plan? And I have to say it's when there's a big milestone event. And also it's worth periodically, like every 5 years or so, going back and looking at it and doing a little research and asking yourself, have things changed? Have they changed in my life, or has the law changed? And sometimes you might need to turn to an attorney for some consulting on that. When there are these big changes, we often write about them in our landowner alert system, which is our email that we send out about twice a month. And so there are just ways, if you're reading the paper, if you're listening to the news, if you're following us on landowner alert, that you may become aware of the changes. But that's one of the things that you need to do to keep your estate plan updated, is kind of think there's both changes in my life, maybe one of my executors has passed, and there's changes going on in the world that might affect my estate plan. Okay. I can do a lot of talking, y'all. Do we have any other questions right now? Anything that jumps to mind?
Yes, Margaret, I have a question.
Yeah.
Specifically on what you were just discussing, changes in the law. This infrastructure plan that Congress is talking about, they're talking about partially funding it by taxing unrealized capital gains at death.
Okay.
And I was wondering if you had any thoughts on how a landowner might want to prepare for that, especially if the vast majority of the value of their estate is tied up in land that's appreciated considerably.
Yeah. So I have to say today I don't have any magic bullets for you. But what I understand that when you talk about unrealized capital gains, but another way that I believe you hear it phrased is whether property is going to get a step up in basis on the death of the owner. So how our law works currently is that if land passes at death to the beneficiary, all of the land, all the real property gets a step up in basis. So if the land was acquired for like $100,000, you bought a parcel for $100,000 or a home, and on your date of death, it's actually worth $200,000. Then the basis changes from 100,000, and the basis is what is used to determine capital gains, to 200. And so if your beneficiary sells it for $205,000, then their capital gains tax is calculated on $5,000 as opposed to being calculated on $105,000. So it reduces their tax liability a great deal. And we call that the step up in basis. And I'm interpreting when you say unrealized capital gains, that's what that step up eliminated, was it got rid of all those capital gains that were embedded in the property because the value was going up by stepping up the basis. And I will tell you, every time taxes are looked at and the government is looking to get in more revenue, there's a big question on whether they eliminate the step up in basis. It's been a question for a number of years. And so that's why I don't have like an answer on what do we do about it. Because we're not, I mean, one of the things might be that you transfer now when you know what the unrealized gains are and what the capital gains tax is. But that's not necessarily a very satisfying answer, and that has a lot of risk in it.
Thank you.
Any other questions? I told you that we hit topics. Now we could have like a whole hour on tax, but it might be hard for y'all to stay awake through it. So we try and mix it up with other stuff. Let's go into the next slide. Fully implementing your estate plan, and this is really the last consideration for everyone. Your estate plan is going to have different documents. It could be will-based and it could be based on a living trust. Those are two different strategies. The will is going to take you through probate. Probate in Texas is not tremendously difficult if it's an independent administration, and a good lawyer will set up your will so that it's an independent administration. And I think there are some creditor protections through the probate process, but it also means you have to be in the judicial system, and some people aren't thrilled about that. The living trust puts all your assets in the trust, all except for your tax deferred assets. And when you pass away, well, the trust still holds title. So the trustee designated in the trust does the similar work that an executor would do. It pays your bills and it distributes your assets to your beneficiaries the way that you want them to do. So the guts of the will and the guts of the living trust can be exactly the same. Either tool doesn't change how you give your assets to the people you care about. It's a different tool. And if the living trust is fully funded, meaning all the assets that need to have title transfers are in there, then you don't go through probate. But things happen. And so we always do a short will with the living trust called a pour over will, so that if one account was forgotten, or turns out that you inherited Aunt Sally's mineral interest and you did not know that, or when you were doing your living trust planning, you just forgot that there were mineral interests in one West Texas county, but you forgot about the other West Texas county. Then your family has the ability to open probate, capture control of that asset, and put it in the living trust, and then distribute it the way you want. So that's what a pour over will does. Your other documents, like we mentioned, are the financial powers of attorney. You might have a HIPAA document where you're making sure that your agent under the medical power of attorney can freely converse with the doctors and the medical establishment in kind of that transition period when they're verifying capacity. A living will is also called a directive. That's where you might give your family some direction on how much end of life care you want. Appointment of agent to control remains. This is another estate planning document. It just helps you designate who's going to interact with a funeral director upon your death. And it takes a lot of stress off of families when you do this little document. It's not a very complex document, but it provides a lot of clarity to the family, and that at a time when they're kind of distressed. So it's really useful. A personal property memorandum, because our jewelry and our guns and our artwork and our tools and our household goods come in and out of our lives fairly quickly. We don't write about them directly in the will. Sometimes I'll do it if it's like an antique that absolutely has to go to X person. But most of the time we use a memorandum that lets you designate who's going to get those items that are personal to you, and that have value, either economic value or sentimental value. But you need to make sure most of that stuff is done, because it's all guidance to the next generation, or it's guidance to the people taking care of you if you become incapacitated. It's the way, if you fully do this, it's the way you have a say in how it's done. And then that last line is we do need to make sure that beneficiary designations on our financial accounts, sometimes the transfer on death deed, things like that, coordinate with our will or our living trust. And they can, here's a quick example. I like beneficiary designations a lot. But if we want some of our financial assets to go to a grandchild, that grandchild's going to be a minor. And we want to create the trust that holds those assets until that grandchild's no longer a minor. And we kind of push it into their 20s so that they're kind of fully cognitively developed. So those assets aren't going to get to that trust unless the beneficiary designation gets those assets to the will, or you don't have any, you kind of leave it open. So we just want to make sure, if we're going to put some good structures in your will and your living trust, that we direct the assets to them. If we just have a beneficiary designation on everything, then they're going to pass directly to those people. And these cool tools and protective tools that we used in the will and the trust aren't going to have any work to do. So how are we doing on time? We still have a chunk of time. Are there, I wanted to focus on the top 5, but each of you came to this webinar today with some questions about estate planning on your mind. Are there some topics that I haven't hit that you feel are important to you? Okay. And Avalon or Mark, there are a few things we talked about kind of as we were preparing. Is there anything that comes to mind for you?
Yeah, Margaret, I think one of them that came to mind was how to stay on top of the changes in the law and why it's important. I think you sort of touched on that. If you want to further clarify that, feel free.
Yeah. So, I mean, some of it requires continuing to educate yourself. Right. And one way that I think it can be a little easier to educate yourself is to follow us on Landowner Alert. And that's this email that we send out if you subscribe. We're not going to send you an email unless you ask us to, but it's really, it's handy, and it's a short email. It usually has 2 or 3 topics related to concerns landowners may have. And several times a year, we include estate planning topics. And I promise you, if there's been a change in the law, like when the Secure Act changed in 2019, then, that was in December, and hopefully within January or February, but definitely in the first quarter, we had an article out on it. We're following the changes in the law, and we want to continue to educate our followers. And so that's going to be an important article to me, is, something changed in relating to IRA designations. So that's a great way to do it. And then the other thing about Landowner Alert is there's also really good articles about condemnation, which is always a threat to a landowner. There's, we have a lot of infrastructure, pipelines, utility lines, expanding roads, and we keep up with that. We have attorneys that represent landowners only on those matters. And so that's going to be in there. There's going to be articles about property tax. There's going to be articles about risk management, like how do I take advantage of the Texas recreational use statute, which lowers my liability to guests that come to my rural land. And how do I, what if I have a fence dispute or a boundary line dispute with my neighbor? How do I resolve that? And we have topics like that. And then certainly the conservation topics about how conservation easements work, what's the difference between a donated easement and an easement for which you might get some compensation. So Landowner Alert I think it's real interesting, and it's an easy read, and I encourage you to subscribe. You might like it.
Perfect. Thank you. One of the things, and I know this can be confusing, sometimes it is for me. Can you go back to the slide we were discussing an LLC? Can you give us a quick down and dirty of the difference between a limited liability company, an LLC, and a limited partnership?
Yeah, that's a good question. And I do a lot of this work because it's really helpful to families, as you start out with mom and dad owning the land, or maybe two brothers. Often I have like two siblings owning the land, and they know that the next generation is going to have like 6 owners, and they can see that the next generation may have 12 owners. And so passing down undivided interest in land is just harder. And if we put it in a business entity, then you start passing down interests in the business entity, and the business entity has a rule book. It's called the partnership agreement or the operating agreement for an LLC. And so that rule book is what helps families decide how are they going to pay the bills, and how are they going to vote about changes, and how are they going to let someone out of the partnership if they realize they're not enjoying the land anymore and it's held by the partnership. So it creates a really nice structure for families to hold land together. So your question was, what's the difference between a family limited partnership and a limited liability company? They are very similar. A limited partnership is a partnership. It's just a state entity that's called a partnership, and it has a general partner and it has limited partners. And those limited partners are kind of like what we call silent partners. They have an ownership interest, but they're not doing any of the management. They're not doing any of the decision making. As limited partners, they also don't have any liability, or they have very, very little. So it's a great way to limit liability to the individuals that are owning, while they still participate. They still own, they have activities. There's a few decisions that need to be made by the general partner and the limited partners together. But most of that day to day, I'm going to hire an accountant, or I'm going to go ahead and we're going to harvest timber. We're going to do a timber sale. Then that general partner's handling all that business stuff. And that general partner then has more liability than the other partners. So that's what, and we call it a family limited partnership when we're really limiting ownership to family, and we're putting in some rules that make it really, really hard to sell to your next door neighbor or someone who's speculating and trying to invest in other people's land. This is really a structure that's there to help families manage their property. A limited liability company looks just like a limited partnership, but we don't have that general partner, limited partner relationship. We make everybody a member. They have limited liability, but then we either designate a manager or we give all the members some decision-making power, and their liability is limited to the extent of that decision-making power. They look extremely similar, the two entities. They have a few differences, and there's some tax benefit, franchise tax benefit to the limited partnership if you're going to go sell the land. And again, that's another one of those half-hour webinars. But they're very similar, and I do both. And I feel like once we understand your goals, if simplicity is a goal, then the LLC is a simpler structure. If really doing some interesting things about management and control is a goal, then we might use the limited partnership structure with a general partner.
Excellent. Thank you.
Yeah. So the one thing, the perk about these business entities, and what's weird about them is they're not necessarily money-making businesses. And that's sometimes awkward to people, but it is still authorized. You don't have to be generating a lot of income. But they do two things. They provide some asset protection, and then they facilitate joint ownership.
Okay, good. Again, I know we're got a little extra time. One thing I did want to just throw out there, back when I started working with Margaret on our estate plan, some of these things are unknown to a lot of us. And it's amazing what somebody like Margaret can take and do and simplify this, what can be seen as a daunting process, to have somebody that understands that. So Margaret is available for questions. This is not just a one and done deal. You guys can reach out to us. Y'all can call us, you can email us, and Margaret will just be happy to answer some initial questions and see where it goes. And Margaret, do you want to touch on that at all? Just what that initial conversation may look like?
We commit to people that contact us. If they'd like, we can set up, a 20 to 30 minute consultation call where we help them kind of think through this and think through, is this what I need to do? Am I ready to set up my estate plan, or am I ready to evaluate the estate plan I already have and see if it needs updates? And how we handle that is, if you do hire us, we'll wrap that 30 minutes into the budget. So we're going to give you an estimated budget for what the cost is going to be, and that's going to get factored in. But, it's no risk to you if you don't hire us. If it's not the right fit, or if it's not the right time, because I'm hoping it would be a good fit. But if it's not the right time, then we've had the conversation. And I will have to tell you, I enjoy this practice a great deal. And I am happy to educate people, and I'm happy to encourage them to continue to educate themselves to figure out how they can put together an estate plan that works for them. And at a minimum, get their powers of attorney in place, because my biggest concern and distress is when someone is exploited. And we have cases like that. When someone gets sick and they get isolated, and a neighbor comes in as a caregiver and then starts taking over their assets in very disturbing ways. And it's an easy fix. If you can get powers of attorney in place, if you can communicate with your family or with friends about what your expectations are, and continue that conversation, then you do a lot to protect yourself. And so it's important to me to have these conversations with you and encourage you to have me help you, or at a minimum, continue to educate yourself.
Excellent. Excellent. Avalon, I know you're still on with us. Any other housekeeping before we turn Margaret off?
The last thing I would say is that if you do want a copy of this presentation, it has been recorded today. We're happy to send that to you. Whenever you registered, we actually have your contact information. So we'll be sure to follow up and share this link to the recording. And I think that's it.
Well, thank you all for your time.
Thank you, Margaret.
Thanks, Margaret. See y'all.
Bye-bye.